I read a really interesting case yesterday. If you're someone who is acting for a person and the other side alleges that they have an alcohol misuse issue, which poses an unacceptable risk of harm to the child or the children, or you yourself are that person, you're going to want to save this video and read this case. You can view the entire judgment for free using Ostley. I'll pop the citation in the comment section down below. In this case, mum said that dad had an alcohol use issue and that he drank alcohol excessively daily. And dad said, look, from time to time, I might consume alcohol excessively, I might binge drink, but never when I'm caring for the child. And I don't have an issue with alcohol. There were a range of hair tests taken during proceedings. So hair tests can actually test a history of 3 months, sometimes longer. And some of those results were low to moderate, and 2 of them were excessive. The father was able to produce a liver test that said that his alcohol use wasn't consistent with chronic use. There were other factors in the father's favour. For example, he was a construction worker and he was required to take alcohol testing on site, and the court noted that the mother could have subpoenaed those records and she chose not to. Really importantly, the father had no history of drink driving or criminal offences relating to alcohol-related offences. At the time of the hearing, he had a new partner and a child in that relationship. He lived overseas due to work, and the father's position was that he wanted to move back to Australia and spend frequent time with the child. I find this case really interesting because even with the excessive hair test results, the court made orders to increase the father's time, including overnight time. I think ultimately it was 3 nights a fortnight, time during school holidays. But most importantly, I found it really interesting that there was no orders for ongoing hair testing in this particular case based on this particular factual matrix. Particularly, he didn't have the criminal record or any independent evidence relating to an alcohol use issue. In this case, the court made orders for the first 10 visits of the father's overnight time. He was to do a breathalyzer at 10 p.m. at night and then again at 8 a.m. in the morning. And the results were to be less than 0.05, so he could still drive a car at 10 p.m. and then 0 in the morning. So a really interesting case and one to keep up your sleeve if you yourself are the person who says, hey, I do drink sometimes excessively, but never when I'm caring for the children, or you're acting for that person, or you're seeking orders for breathalyzer, for example, at night and in the morning, rather than final orders for long-term hair testing. Now, again, every case is determined on the particular facts of that particular family and matter. And so just because it happened in this case doesn't mean it's going to be ordered in your particular case. Speak with a lawyer and they'll be able to provide you with advice regarding how to mitigate the possible risk issues in your particular case. But in this case, the court found that the alcohol allegations were sufficiently mitigated by the breathalyzer types of orders.